You know, a will is so much more than just some legal document. It's really your final message to the world. It's the ultimate act of deciding what happens to everything you've worked for. But how does that whole process actually work, especially under Ghanaian law? Well, today, we're going to dive into the world of last wishes and the legal rules that bring them to life. So, here's the game plan. We'll kick things off with the basics of what a will even is. Then we'll get into the surprising limits on your freedom to give away your property. After that, we'll cover the absolutely critical rules for making a will valid, see how it actually comes to life after death, and finally, we'll try to decode some of the trickiest legal situations you could possibly imagine.
All right, so let's jump right in with the absolute basics. What exactly is a will? And the person creating it, they're called the testator. They are the star of this whole show.
Now, this is a classic definition from Blackstone, and it might sound a little old school, but it's actually super powerful. It all comes down to one word: intention. A will has zero force while you're alive, but the moment you're gone, it becomes your voice. It's your instruction manual for what happens next. But of course, it's not like just anyone can make a will. The law has some pretty clear rules. You've got to be at least 18. You have to be of sound mind. The legal term for that is compos mentis. And crucially, you have to be doing it of your own free will, no threats or pressure. There is one really interesting exception, though. Members of the armed forces on active service can actually make a will at any age. Okay, so you might be thinking, it's my stuff. I can do whatever I want with it, right? I can give it all to whomever I choose. Well, not so fast. This is where the law steps in and things get really interesting. I mean, on the surface, the idea is simple. It's your property, so it should be your call. You get to pick who benefits. But, and this is a big but, that's not the whole story. The law actually steps in to create a kind of safety net, for people who might be left vulnerable. And that safety net has a name: Section 13 of the Wills Act. It was specifically designed to prevent hardship for a testator's dependents. It's a powerful reminder that no will is ever written in a total vacuum. So if a dependent wants to challenge a will, they can't just show up and ask for money. They have to convince the High Court of a whole bunch of things. First, that they actually are a dependent. Second, they have to apply within the time limit. They also need to show that the will failed to provide for them, prove that this is causing them real hardship, and finally, persuade the court that, all things considered, they really do deserve that support. It's a high bar for sure, but it's there for a reason. And this brings up a really tough question, Laws are meant to be clear, but what about justice? What happens when following the rule to the letter just feels wrong, when it leads to a really harsh, unfair outcome? And wow, this case, the Humphrey Bonzu case, it just perfectly captures that dilemma. A disabled child who happened to be over 18 was left out of a will. The majority of judges basically said, look, our hands are tied, the law says under 18, and that's the end of it. But one judge disagreed, calling that interpretation draconian and harsh. He argued that it missed the entire point of the law's protection. It's this amazing clash of legal ideas. Do we stick to the exact words on the page, or do we look for the spirit of the law? All right, so we've talked about what can go in a will, but just as important is how you make it. There are some hard and fast rules here you absolutely cannot ignore if you want it to be legally official. Think of these as the absolute non-negotiables, the bedrock of a valid will. It has to be in writing, the testator has to sign it, that signature has to be witnessed by at least two people who are both there at the exact same time. And then those witnesses also have to sign it, all while the testator is present. It sounds like a complicated little dance, but every single step is there for one reason: to prevent fraud. Okay, but what happens if the person making the will is blind or can't read the very document they're signing? How does that work? Well, the law actually thought of that. There's a special protection built right in. It's a clause called a jurat, and it's basically a statement at the end of the will that confirms everything was read out loud and explained to the testator and that they completely understood it. But is just having that little clause there the final word on the matter? Absolutely not, and I love this quote from former Chief Justice Georgina Wood. She said the courts must not make a fetish of the jurat. What does that mean? It means the court's real job isn't just to check a box. It's to figure out if the testator truly understood what they were signing, whether that special clause is there or not. It's all about substance over form. Okay, the will is written, it's signed, it's witnessed, it's all official. So what happens when the time comes? Let's follow that journey from a piece of paper to a real-world action plan. So the second the testator passes away, the will kind of activates. But here's the key. It doesn't have any real legal power just yet. The executor can do things to protect the estate, but they can't start handing out property. For that, they need the court's official stamp of approval. That process is called probate. Once probate is granted, then the will has the full force of the law. All right, for this last part, let's dive into the deep end. We're going to look at how the law handles some of the really weird, tricky, and complex situations you can imagine. This is where things get super interesting.
Okay, check this out. It's called the Colmorientes rule. Imagine a really tragic situation, like two people dying in a car crash at the exact same time. The law has to have an answer for who died first, because it matters for inheritance. If it's a testator and their beneficiary, the law presumes the beneficiary lived longer. But if it's married spouses who die without a will, the law presumes the older spouse died first. It just goes to show you how having a will can totally flip the legal outcome.
And then there's this other wild concept, the rule against perpetuity. The best way to think about it is dead hand control. It's literally the law stepping in to stop people from controlling their property from beyond the grave for generations and generations.
So how does the law stop this? With a formula. Any gift in a will has to be locked in. It has to become legally certain within 21 years of the death of someone who was alive when the will was made. Basically, it stops you from saying, this house goes to my great-great-great-great-grandchild. It all boils down to that simple formula. A life in being plus 21 years.
So you might be asking, why does this rule even exist? What's the point? Well, it's actually super practical. It's to make sure that property, like land and houses, can be freely used, bought, and sold by the living, instead of being locked up forever by the wishes of someone who's long gone. And really, that brings us full circle. A will is your final instruction, for sure, but when you look at all these rules, the limits on your freedom, the rules against controlling from the grave, it really makes you think, doesn't it? What is the ultimate purpose here? Is it to provide for and empower the living, or is it one last attempt to control things from beyond? It's something to think about.